Welcome, everyone. All right, let's just dive right into this explainer. If you're sitting there as a South African law student, maybe trying to figure out exactly where to begin your journey, well, you've arrived at the absolute bedrock of our modern legal system. Today, we're unpacking the monumental 1995 constitutional court case of SV Makwanyane. And listen, this isn't just, another case to memorize for your exams. This is literally the genesis of our entire human rights jurisprudence. Let's get into it. So, here's our roadmap for today. We're going to cover Welcome to Constitutional Law, the ultimate test case, life, dignity, and arbitrariness, the two-stage approach, the power of Ubuntu, and finally, a culture of justification. Section 1. Welcome to Constitutional Law. To really wrap our heads around the law today, we absolutely must understand the monumental paradigm shift that hit in the early 1990s. Honestly, without this context, everything else is just dry academic theory. See, under the old system, parliamentary sovereignty, the state could effectively do whatever it wanted. If Parliament passed a law, no matter how oppressive or just plain unjust, the courts simply had to enforce it, right? As long as they followed the procedural rules, it was game over. But then, boom. Enter the interim constitution of 1993, ushering in constitutional supremacy. Suddenly, the law wasn't just a blunt instrument of state power anymore. It was subject to a supreme document guaranteeing fundamental human rights. Any law inconsistent with it, totally invalid. As a law student, you've got to engrave this in your mind. The Constitution is supreme. Moving on to Section 2, the ultimate test case. Which brings us to the ultimate crucible for our newly bold Constitution. Picture it. The year is 1995. The Constitutional Court is brand spanking new, and their very first major task? Deciding the fate of the death penalty. You had these two men, Makwanyane and Mchunu, who had been convicted of brutal murders and sentenced to death under the old Criminal Procedure Act. But their appeals were postponed specifically so this newly formed Constitutional Court could answer one simple yet incredibly profound question. Could the state still execute criminals under a constitution that explicitly guarantees the right to life and protection against cruel, inhuman, or degrading punishment? And you have to realize this wasn't just some theoretical exercise for a university lecture hall. Between 300 and 400 people. That staggering number represents actual human beings who were sitting on death row at that exact moment, just waiting for this ruling. Their lives quite literally hung in the balance. So the stakes for this new court, they literally could not have been higher. Section 3. Life, dignity, and arbitrariness. Now, when deciding on the constitutionality of the death penalty, the court didn't just sit back and look at abstract legal definitions. Nope, they looked at how the law actually operated on the ground. They deconstructed the systemic realities and recognized a really harsh truth. Who lives and who dies wasn't just about the crime itself, it was all about the system. Most of the accused were poor, they were black, and they were defended by young, inexperienced pro-Dio counsel. And they were facing judges who were almost entirely white and middle class. Plus, vital testimonies were often filtered through interpreters, losing so much crucial nuance along the way. The court basically realized that capital punishment was heavily biased by race, class, and just the inherent element of chance in the courtroom. It was, in a word, arbitrary. This crucial point was perfectly articulated by the president of the court, Arthur Chaskelson. He viewed the death penalty not just as a severe punishment, but as an irremediable annihilation of fundamental human rights. Because, think about it, life and dignity are completely intertwined. You just cannot strip someone of their life without completely destroying their dignity. And doing so in a system that is just fraught with arbitrariness, well, that makes it the very definition of cruel, inhuman, and degrading punishment. Section 4. The two-stage approach. All right, so as a law student, you've got to master the actual mechanics of constitutional litigation. It is not enough to just stand up and say a right is violated. You have to prove how the law treats that violation using what we call the two-stage approach. Step 1, you ask, has a right in the Bill of Rights been infringed? In Makwanyane, the answer was a resounding yes, the right to life, dignity, and freedom from cruel punishment. But then we hit step 2, the limitation clause, which was section 33 in the interim constitution. You have to ask, even if a right is violated, is there a compelling, reasonable, and necessary justification for the state to do so in an open and democratic society? The state tried really hard to argue that they needed executions to deter violent crime, which, yes, was a major problem in South Africa. But the court firmly struck this down. They ruled that while combating crime is absolutely vital, there's just no concrete proof that the death penalty deters crime any better than life imprisonment. Therefore, taking a human life was neither reasonable nor necessary when locking someone up for a long time was a totally viable alternative. The death penalty failed the limitation test flat out. Section 5. The power of Ubuntu. Now we arrive at what is arguably the most groundbreaking, distinctly South African element of this entire judgment. The interim constitution actually contained a postamble that explicitly called for a need for understanding, reparation, and Ubuntu, basically shifting our entire legal focus away from vengeance and toward conciliation. Now, Ubuntu translates broadly as humaneness. It's this profound, beautiful idea that your humanity is inextricably tied to the humanity of everyone else. The court took this distinctly African philosophy and used it not just as cultural background context, but as a core interpretive legal value to actually decide the case. Justice Pius Langa brilliantly illustrated this concept. He noted that, sure, while murder is an absolute rejection of Ubuntu, the state turning around and executing the murderer is also completely bereft of Ubuntu. A society that genuinely respects human dignity and humanities just can't claim to uphold those values while simultaneously mimicking the cruel, retaliatory behavior of the violent criminal. The state has to lead by example. Adding to that, Justice Albie Sachs highlighted how traditional African societies possessed highly developed, incredibly rational systems of justice long before colonial law ever arrived. And these systems often prioritized community balance and restitution way above state-sanctioned killing. Take the Sotho king Moshoeshoe, for example. He famously opposed capital punishment. The traditional logic there was deep. Why sacrifice a second life for one that's already lost? It doesn't bring the victim back, right? This proved that rejecting the death penalty wasn't just some imported Western ideal, it was deeply, deeply rooted in indigenous African jurisprudence. All right, bringing it home with Section 6, a culture of justification. Let's pull all of these threads together so you can really grasp the final legacy of this case, for you, the future lawyer. The Makwanyane decision did so much more than just abolish the death penalty. It signaled a permanent, irreversible departure from the past. We officially crossed the bridge from a culture of unchecked authority, where the state could literally kill you just because Parliament said they could, into a culture of justification. In this new era, every single exercise of state power, every law, and every legal action absolutely must be rationally justified, and it must deeply respect human dignity. And that brings us to the end of our explainer today. I want to leave you with a final, vital thought to carry with you throughout your legal studies and well into your career. The Constitution is a supreme promise to the people of South Africa, right? But it relies on lawyers and judges to actually give it breath. The law is now yours to protect. So how will you wield it? Definitely keep that in mind as you head to your next class. Catch you next time.